welcome back. I'm speaking with Des Carty from the Common Law Society, and we're slap bang in the middle of the book Irish Life and Me, Tales of the Criminal Cabal. And I must say I'm finding things very interesting indeed, Des. How are you keeping today?
I'm grand. Yourself, John?
I'm very good. No complaints about the weather as usual. So we're going to crack straight onto this. We're up to chapter 5, which is called Notice to Commence Investigation. How can you kick us off with this one?
Well, to kick us off, John, what I'd say is just to remind people of what we have previously covered, because I know people may be jumping about a little bit. So in the previous chapters and the interviews we've done, we've covered the initial letter that we got from Laura Skelly, which comes into play again in this chapter. What Laura wrote on back in February, March or April of 2012. And then off the back of that, off Laura's letter and insinuations and allegations, a data protection request was sent in. And obviously you have to give 40 days then for that to come to fruition, whereby they'll return all the data that they have on file or may not.
Yeah.
And then we went into, after that, talking about Ray McSherry as Mac the Knife in chapter 3, if I'm not incorrect in saying that, or chapter 2. And then we talked about the Central Bank Reform Act, whereby we put in questions into the central bank and into permanent TSB in relation to the fitness and probity of their directors. In other words, challenging whether or not these people should actually be doing the job that they're doing as directors, given the financial crisis that they've all led the banks into and us into as well.
Yeah.
So that brings us up to the end of chapter 4. And then what we proceeded to do with the man Tom is we issued a notice to commence investigation, which means that we were putting all the regulators on notice that they should consider or should be directed towards investigating these matters and keeping an eye on what was going on. So we also wanted to sow some seeds with them to let them know that basically they themselves were on notice to continue with this and keep an eye on this, and to let them know that we inferred certain things within the letters, that basically the Irish Life and Permanent TSB were doing certain things that were against the regulations that the regulators had in place. So we wanted to also inform the directors and the employees of Permanent TSB and sow seeds with them to let them know this was not going to be dropped, this was not going to be let go of, that now that they have stepped up to have a fight, that Tom and people that were behind them were prepared to have a fight. So we wanted them to let them know that. And we were also looking for allies as well by writing these letters, because we wanted to let the employees of the bank know that they needed to keep an eye on the directorate, because the directorate of the banks are connected in what's called the Golden Circle, or the Irish Golden Circle.
Yeah.
So with that then, we wrote to everybody. Again, it was an open letter, and we weren't hiding anything or keeping anything back. And we wrote to the regulator, the authorities, and said, look, we're putting you on notice now that you better step up to the plate, start keeping an eye on things, and start investigating these matters. And, of course, we got the usual trite response. And I think the Data Protection Commissioner wondered why we were writing to him, or why Tom was writing to him. And he quoted, and he said something like, well, what's this got to do with us? And we said, well, because from our knowledge and from our research, we are taking it that Irish Life and Permanent TSB have done stuff which may be a breach of the Data Protection Act. And again, we were referencing back to all the other regulators and pointing out where we felt there may be breaches in various regulations, that they have a duty of care to investigate if they suspect something untoward has gone on.
Yeah.
So immediately the Data Protection Commissioner kind of went into denial about it. But we said, look, if the Permanent TSB, we pointed this out under their regulations, if the Permanent TSB have shared data with third parties of any sort or form or type, then that is a clear breach of the Data Protection Act. And that means that if we began to infer then, even at that stage, that Permanent TSB, Irish Life, may have sold, traded, exchanged, swapped, securitized the alleged mortgage or loan. So with saying that to the regulator never bothered responding back to us.
You see, this in itself, Des, is incredible. Sorry to cut across, but I'm listening in astonishment here, because we have all these bodies set up supposedly to protect the interests of consumers and the general people out there, and they're as blatantly as that, in most cases ignoring any kind of a reasonable request for information or for some kind of answers, and going one step further in a lot of cases and actually saying, hang on a minute, this has nothing to do with us, when patently it is.
Yeah, they go into immediate denial, but that is protection, a form of protection. You see, they're kind of going on the attack, which actually feeds us information, because if they're going on attack, they have something to protect. You see, they have vested interests of some form. Which, you see, it lends itself to the idea that we put out there earlier in the interviews, that the regulators are state-run, state-controlled, so they're not going to do anything too untoward against the state. But they still have to give off the air of being independent and being separate from the state and being able to regulate independently. But they're not, because they're paid, they're controlled, they're run by the state. And the heads of the different regulatory departments are all political appointments as well. So they're not going to put their own positions and posts in jeopardy, and their wages and their salaries. You see, there's big money in this for people at the top of these little chains or at the end of these chains. So they don't want to jeopardize any of that for themselves and go out on a limb and actually do the job. Now, this is what we keep saying to people, John, is the law and the regulations are there, and we say to people, research them. The law actually, as we said before, it's actually a good thing. Now, it's a good thing for probably a few different reasons, but the main reason is that if you are able to read the law, now it does take some time, I agree, and it takes us all some time, including me. When I'm sitting down looking at a new act or statute or code, it does actually take me a while to grasp what's being said.
Yeah.
But they are there primarily to help protect people. And what we have found consistently, very, very consistently, if that's the right way to put it, is that the people within the regulatory departments, even the top ones, and solicitors, barristers, blah, blah, all these so-called professionals, they don't actually know these regulations that well, and they don't know the statutes and acts and codes.
Right.
Because if they did, they'd actually have to do, and they'd be operating from a point where it's very clear parameters what they can or can't do within the regulations and the acts. But because they don't know them, they're probably too lazy to read them. And I suppose if you're on a big salary, as far as you're concerned, all you're there to do is to make decisions as opposed to actually implement procedures, policies, regulations. But the regulations, the policies, the procedures, the acts, the codes and the statutes, if people read them and read into them, they'll see that they can use them as their weapons against the state, against the council, against the banks. Because the regulations are there. The trouble is, we've let it go on so long without enforcing the regulations that are in place. That it's slipped, and we've slipped. So we're letting them away with this thing. Now, this is why we published the book as well, is to point this out to people, that the law is there and you can make use of it. Now, the law is sometimes an ass as well. There's things in the law that are not morally correct or whatever. But primarily, you can find something that will help protect you or defend you or attack the other side if necessary. And we had no trouble, once we put our minds down to it, to find these things that actually do help us.
Yeah.
All we were doing verbatim, John, was referencing back to their acts and codes and statutes. And you can see that when we got into a debate with the financial ombudsman. He actually contradicted himself on more than one occasion, misquoting his own act and then changing his mind about the act he wanted to use.
Okay.
So blatant ignorance, and then duplicity as well to compound that. And then he not just ignorance, but he was so, I suppose, arrogant in his own knowledge about this that he got it wrong. He just got it wrong. And we caught him out on a lie, basically. That's how we'd constitute. Anyway, look, we've sort of gone off track with that. So we wrote to the regulators and authorities, so on and so forth. Now, again, the usual thing, John, they didn't come back to us with anything concrete. They were just sort of like, well, thanks very much for writing. We appreciate it, and we're going to put your information on and all the rest of it. Yeah. And where they wrote back to us and denied and didn't want to do something, then we returned serve on them, and we said, well, according to the Act, Code, Statute, whatever regulations, you have to do this. And we pointed categorically and clearly out what they had to do and what they were responsible for. So that was fine. We knew we weren't going to get too far with these anyway, but that was fine. We knew that from the start. So what we did then was we're always going back. You need to keep going backwards to go forward. So we kept going back to the letter that Laura wrote, and we hadn't responded, or Tom hadn't responded directly to Laura. Okay. And we kept pointing this out to Tom. Tom, you need to respond to Laura because she's made some very, very serious allegations in what she's written. We comment on that in the book, and we just comment on the language that she uses and the words that she uses, so on and so forth. So we sat down with Tom and we worked up a letter with him. And I think, John, for the purposes of making sure this is clear, we should read out the letter that we sent to Laura.
Yeah.
Is that fair enough? I just want to make sure I have it in front of me. Okay. Yeah. Now, not forgetting now that Laura was alleging there was a debt, and alleging that she was going to go to the court, and alleging she was going to gain possession of the property, so on and so forth. So there was 3 or 4 threats in her letter, and the language then was coercive and threatening, so on and so forth. So keeping that in mind, Tom wrote to Laura and said, "Dear Laura Skelly, we hope this day finds you well and in the best of health. We note," he's a nice cordial man, you see, he's nice and cordial with her. "We note your letter on the 26th of March 2012. You will be aware that we have responded appropriately and have issued a notice demand under the Data Protection and Freedom of Information Acts, alongside a set of questions pertaining to fitness and probity." So again, this letter is a kind of an update for the previous letters that were written. So Tom mentions the Data Protection and Freedom of Information requests, and also the questions on fitness and probity that were sent in to the bank itself.
Right.
Okay, we'll go on from there now. This letter is directed more towards the startling and serious allegations, claims and threats and demands for money you yourself have made within the body and content of your letter of the 26th of March. Now, not forgetting, everybody that's listening, that the letter that Laura sent out was a pretty standard letter. It wasn't something that was purposely or specifically designed in this case, but it was a pretty standard letter that most people will get after they allegedly default on a mortgage or an alleged loan. So we go on. Your allegations are unfounded and unsubstantiated. You make unsubstantiated demands and claims for money that you infer is owed to you and our permanent TSB. These demands and claims are, as you well know, are legally and lawfully unsound and most definitely unfounded. This is called extortion and is criminal. It goes on then to quote the relevant act. Extortion is defined as, this is a legal definition of extortion. Extortion is defined as the act or practice of obtaining something or compelling some action by illegal means as by force or coercion. Again, force and coercion are legally defined within the Non-Fatal Offences Against Persons Act 1997. Yeah. Go on now. You compound your extortion and go on to threaten that you are going to recover possession of premises that you neither own nor have a legal or lawful claim to by virtue of stated arrears. Yet, Laura, you have never substantiated, proven or provided any evidence to support your unlawful claims. You are using coercion in order to harass, extort and extract money / revenue, that which is precluded by law. You threaten to take property and take proceedings in some circuit court. This is at least an offence under the Non-Fatal Offences Against Persons Act 1997. Final note here is, we have taken counsel on this matter, as in Tom has, and reserve the right to issue legal / lawful proceedings, should you not persist in the manner in which you have previously conducted your affairs. So that letter was sent to Laura, obviously. I think, from memory, it might have been also copied into the other parties as well, but I'm not clear on that. So that was that. And again, John, the question would be, did we get an answer or a response to that letter?
Well, I'd be very surprised if you did.
No, of course you didn't. Again, Laura would have been told to keep quiet and keep her mouth shut and not respond, because anything that Laura might say or respond to it from that point forward would incriminate her as well as the bank.
And just to interject there for a second, Des, because a lot of people might have this question, and it could be pure speculation on our part, but have we any indication as to the processes that go on when these letters are received within the institutions that receive them? Are they ignored? For example, if Laura, this arrives on her desk, would it be ignored, or do you think it would be passed on to their relevant legal teams or legal advisors? What do you think happens in that case?
In this case, I think because the bank were hit so hard with these questions, in the initial stages when the data request was sent in, that would have gone on to their data department. They have a data processing department.
Yeah.
But a letter like this now, where it mentions specific aspects of the law, that would have gone straight up to the legal department. That would have been handed to the legal department. And then the case, if you like, or the reference number which the mortgage or the alleged mortgage was operating under, that would have been watched then. So I would imagine that most letters that came in under that reference number from that point forward would have gone to the legal department.
Okay.
So, well, again, John, it's speculation, but again, it does lend itself to some responses we got later from the legal department. They did finally engage, but they didn't engage in any meaningful way anyway.
Right.
But it just, as I said, once it gets a bit heavy, it gets fired onto the legal department. Now, again, I challenge the validity of any alleged, I suppose, legal operative in the legal department in a bank, and I'd actually challenge the validity of their legal standing as to whether or not they are qualified legally as well. In a literal sense, I'd actually question whether or not they were legally qualified to deal with such matters. And in this case, I wouldn't have been convinced, because the responses that Tom was getting, that the head of the legal department was actually legally qualified. I'd actually be surprised if he was, because he just didn't enter into any meaningful dialogue whatsoever.
Yeah.
And you would expect somebody from a legal background to do so, you know. So that's that. Where do we go next? Vicarious. Oh yeah, just some words that then are peppered throughout that chapter. And the chapter kind of concentrates on expanding on some of the rules of the court. So we were always thinking, as Tom was, that if this ever ended up in a court of law, i.e. High Court, District, Circuit, whatever court it might be, that it would be good to start researching all the or some of the relevant orders and rules of the court, and then coupled with that, to be able to fire them back or fire them into the framework of any letters we did. So just 2 or 3 specific orders that we looked at in relation to the letters, or the letter that was sent into Laura. And I'll just quickly run through these. There's only about 2 or 3 of them anyway. These are the orders and rules of the Supreme Court, and these orders and rules are available on courts.ie. So if anybody's looking to understand the processes, the protocols, the orders and the rules of the court and how things operate in the court and the basis on which they operate, you simply need to go to courts.ie, get in there, have a look around, and you'll see the orders and rules of the court. Now, again, we went to no expense here, and we actually purchased a red book, which I believe now is out of date at this stage. But the red book, if you purchase it from the courts or through the court office or court shop, is about €250. So, again, it's not within the remit of every man to be able to purchase a book like that and then make sense of it. But a good starting point, again, is go to courts.ie. So the 3 main rules we were looking at in relation to this is, first one, Order 19, Rule 13, and it says, every allegation of fact in any pleading not being a petition, if not denied specifically or by necessary implication, or stated to be not admitted in the pleading of the opposite party, should be taken as admitted. Now, that sounds like a bit of a mouthful, but what it's really saying is, if they don't deny, irrefutably deny, as in they categorically deny whatever allegation you're making against them, then it's taken that they've agreed with it. Okay, so if we were to throw allegations, which Tom did, Tom threw some serious allegations. He levied some very, very serious allegations at the bank. None of them were ever denied. Absolutely none of them. So under that rule of the courts, if you're standing in court, he'd be saying, right, well, I said this to the bank and they didn't deny it, so therefore it stands as being fact and truthful. Okay? Right.
So that's very powerful.
It is, yeah. But this is their orders and rules. Again, this is what we're trying to get across to people. The law is there if you're prepared to put the work in. All it is work. I mean, the question we ask, as you're aware, John, when we do a school, when we talk to people publicly, we just say to people, the first thing we say is, we ask this ourselves, are you guys qualified barristers and solicitors?
Yeah.
What qualifications have you got to be able to sit there or stand there and talk about this stuff? And we say, well, we put the question back to you. Can you read and write? And that is the qualification you need. You need to be able to read and write, and that's it. It doesn't require anything else. Now, I know there are people on the island that may be illiterate. That's fine, but they can listen and they can talk. That's all you need. You need to be conscious. That's all.
Yeah. So if you can communicate in some way, well, that's good enough.
Exactly. If you're conscious or conscientious, or you can think, that's all you need, because everybody can think. So that's the only qualification you need. So this again goes back to, I suppose, the social conditioning of people. They have this belief system, inverted commas, that because somebody has letters after the name, or because they have professional qualifications, they're better than them. They're not. They're not. Yeah. In some cases, they're so programmed into one way of thinking that they cannot think critically or logically about anything. That's what we've found. Anybody that's been programmed for so long, their mind blows when we say certain things to them, or we ask them certain questions. So this is where we go back to being able to read and write. If you can read and write, you can get a handle on this. And the likelihood is, as we said before, if you study this, and you will have a vested interest, because if they're coming after you for your home, your property, your business, your land, whatever it might be, you have vested interest in making sure that you get to know this stuff. Yeah. And I can tell you, within 3 months or so, you'll probably know more than the average solicitor on the high street. And that isn't long. And they study for, 4 years, 5 years to become a solicitor? Yeah. So because you have a vested interest, you'll be studying the areas that you need to study in relation to your case. Yeah. So let's go on with these orders. The second order we quote here is Order 19, Rule 22. Now, it has been a while since I read this, so it might come to me straight. So the order is Order 19, Rule 22. Whenever it is material to allege malice, fraudulent intention, knowledge, or any other condition of a mind of any person, it shall be sufficient to allege the same as a fact without setting out the circumstances from which the same is to be inferred. Now, I won't read it again because it is a bit of a mouthful. But what it is saying is that if you're alleging malice, okay, we'll explain malice in a few minutes. If you allege malice or fraudulent intention, so if you're saying, well, the bank had a fraudulent intent and they did it via malice, and they had knowledge that they used in order to make a profit and to do me out of money. Yeah. If you're alleging that, that's all you need to do. You don't need to back it up with anything else. Okay?
And how can that be? Let's play devil's advocate for a second. Surely everything should be backed up.
It should be. But you see, again, they're under a duty of care when an allegation is made to them. Right. First of all, in most cases, they won't deny it. Okay? And in this case, they didn't deny it. And so, in some cases, they do. Now, laterally, they did deny certain things, and they had to. They realized they had to. Well, you see, it is sufficient in law if you're saying, well, there was fraudulent intention. Now, it's not that you don't have to prove it, but in the initial stages, it is sufficient to allege it. Okay, that's all you need to do for it to be taken seriously.
But at some point down the line, you will have to show that. Okay.
When it comes to a court of law, you then may have to provide and produce evidence, so on and so forth. Okay, but it is sufficient to warrant them, including all the regulators, heading towards investigating the matter once you allege these things. If you allege specifically malice, which is an intention to do something that to somebody else's detriment, fraudulent intention, so to do something with the intent to start off doing something with the intention of defrauding somebody, or having knowledge that you know that at the end of the day that they will be down. Having that knowledge, okay? Yeah. And then the other conditions. So if you allege that, that is a starting block for them to have to start thinking about, well, what the hell is going on? And the regulators then have to start saying, well, okay, has been alleged, we need to investigate this. That should be sufficient enough for the regulators to investigate it. Does that make sense?
Yeah, absolute sense. You've cleared it up nicely there.
It'll make more sense because we'll actually expand upon some of the meanings of the words in a second, or a couple of minutes. The final order that we looked at, which is very, very interesting, which, well, we all found it quite kind of interesting, is... now, these are all orders that are come under Order 19 and the various different rules. So there's 1 to 40 orders, I think, 1 to 40 or so rules, maybe more, in Order 19. So, but they're all worth looking at. Order 19, Rule 22 is very interesting. It is saying now this is me reading back about order rule, it is saying that it is enough on its own if you suspect wrongdoings. Okay? So if you suspect there's wrongdoings by another, to simply state or allege that there is a wrong. Okay, which is what the letters did. In other words, you don't initially have to set out the exact conditions or circumstances by which it occurred. So if you suspect a wrongdoing, all you need to do is say it.
Yeah.
And that is sufficient enough to start off the case. The wrongdoings by the order being malice, fraudulent intention, knowledge, or any other condition of the mind of the person. So just to explain the word malice. Malice is defined as the intent, without justification or excuse, to commit a wrongful act, reckless disregard of the law or of a person's legal rights, ill will, wickedness of heart, etc. So that's basically it. It's not difficult to understand, but again, it's in the book, and if people start using these words, that they had those malicious intention there, or fraudulent intention, or there was fraud, they're very powerful words. They're very powerful words. And again, you're making the allegation, so therefore there is a duty of care on those that you're making the allegation about to actually start investigating it and bring all the knowledge within, bring all the facts within their knowledge. So I'll read out fraudulent intention. Fraudulent intention is defined as intent is the mental resolution or determination to do something. So if you intend to do something, you have a determination to do something. When coupled with fraud, it is a mental resolution or determination to commit fraud. So they were intent on committing fraud, like it's in reverse. Then fraud, now fraud is a very, very powerful word. Theft and fraud are words I used to use long ago before I ever came across the sort of stuff we're doing now. But fraud is defined as a knowing misrepresentation of the truth or a concealment of a material fact to induce another to act to his or her detriment. So it is actually a very, 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 very serious allegation to make against a bank or a member, a person within the bank. So fraudulent intent or fraud, a knowing misrepresentation of the truth. So they knowingly misrepresented the truth. So they lied, in other words, or concealed the facts. So they didn't tell you the whole story, full disclosure, and to induce you to act to your detriment. Now the reason we were bringing this in, and the reason I want to make an issue of it today or highlight it, is that we said this before, John. You know, I was challenged on using the word alleged mortgage by another radio show host, and I said, well, it has to be alleged, because who here, any of our listeners, who has actually read all of the banking regulations, all of the law, all of the issue concerning and regulations concerning the creation of money? And nobody that I know, and I haven't read it all, to be honest with you.
Yeah.
So nobody really knows in minutiae and in great detail how money is created and what's done in the background. And most people don't know or understand the process of securitization, if you know what I mean.
Yeah.
So you don't have full knowledge of what's going on. And neither did the bank, neither the individuals within the bank. So this is the reason you would put in the word alleged, because nobody knows. Nobody actually knows. So if they're writing to you and saying, well, you owe us this money, you should be responding and saying, well, the alleged money or the alleged mortgage or the alleged contract, because you don't know how those things were created or what happened. You weren't in full knowledge of the facts. I don't think you were. So, and most people are not. So going back to fraud, a knowing misrepresentation of the truth, the concealment of material fact. So what we're saying here is that we suspect that the bank, when they did their alleged deal with Tom, whatever alleged deal that was, they withheld the facts and some of the knowledge from him. In other words, they didn't tell him that in relation to this alleged mortgage, they were going to take this alleged mortgage, put it into a box and securitize it, i.e. sell it on.
Yeah. Now,
that's concealment of a material fact, which is very serious.
Well,
it's fraud.
It's hugely serious. It is fraud, and it's something that can be backed up then through documentation as well. So I would imagine that kind of, for anybody in the know who's receiving a letter like that, in the banks or wherever it might be, that's going to kind of make their hair stand up on end and stand to attention at the very least.
You see, it probably won't make the front man or front woman that receives it stand to attention. They'll probably pass it back to the legal department.
Okay.
And the legal department will probably kind of get it. Now, they probably won't get it all. They probably think this is a bit crazy, this stuff. because they've been programmed and trained in a certain way to respond. They have a response as opposed to, they don't critically think about something, they respond to it. And this is why we also say to people, if the banks say, I'm responding to your letter, say, no, I didn't look for a response, I looked for an answer.
Right.
If you put a question and someone says, I'm responding to your question, say, I didn't look for a response, I looked for a flippant answer.
Yeah.
Okay?
Yeah.
So don't let them away with the language, that sort of misleading, misrepresentative language either. If they're using that word response, say, no, sorry, just to correct you and to be 100% categorically clear here, we're not looking for responses, we're looking for answers. Questions have to be answered. It's that simple. So this is what banks fear, this is what the legal departments fear, this is what all legal minds fear, is that they'll have to answer questions. Okay. But if you put questions to them, they have to answer them. It's prevarication otherwise, and that's a criminal offence. Okay?
Yet another one.
Yet another prevarication. Okay, the word definition. We've covered knowledge of the facts. So, yeah, knowledge of the facts. Now, again, I won't actually quote it verbatim. But there is a case, a Supreme Court case called Summers versus Weir, SOMERS versus Weir. And in summary, the case is about full knowledge of the facts, to be within full knowledge of the facts. So in other words, if a barrister, solicitor, a bank, whomever it might be perceivably, is coming after you for some alleged debt, whomever is coming after you in whatever representative capacity they have, they need to have full facts. They need to have the full facts. Okay?
Yeah.
If there's any suggestion that they do not, if they don't have knowledge of the full facts, then they're committing a crime. It's called barratry. Okay, now specifically in relation to solicitors very often will just go on the instruction of their clients, i.e. the banks. And very often we would assist people in writing letters and saying, ask them, just as a direct question, do they have facts? Okay, whichever way you want to put it, but you're saying to the solicitor, are you cognizant of all the facts in this matter? Now, 99 times out of 100, they just won't answer that question because they're not. So that means they're committing a crime. They're selling justice for money, which is called barratry. That's a criminal offence. At one time there, for selling justice for money, you could be what's called keel-hauled, which means that they put a rope around your arms, they put a rope around your legs, and they drag you under the hull of the ship.
Delightful.
That's what they used to do for barratry, selling justice.
Okay, it's
serious.
It's kind of a shame they don't do it still.
No, well, I don't advocate violence, but Jesus, I don't know. But no, it's very serious. It's another word that people should put into their lexicon or collection of words, is barratry. Find out the legal definition of it and use it, and accuse, if a solicitor writes to you or a legal department, say, well, are you cognizant of all the facts? Do you have all the facts within your knowledge? And then quote Summers versus Weir, as in a Supreme Court case hearing on which an awful lot of cases precedent. And if once you quote that, they'll think, right, I better look this up. I don't even know what this is, first of all. And then they'll have to look up the word barratry. And then they'll realise, well, if this comes up in court again, and I'm asked the question via the bank, via the solicitor, via the barrister, via the man or woman that's standing there, and I turn around and say, well, I wasn't aware of the full facts at the time, it means I've sold justice for money, which is a criminal offence, and I could go to jail over it.
Yeah.
And it frightens the hell out of them.
As well it should.
Yeah. As well it should. Well, listen, what else is there, John? Do you recall? Oh, yeah, breach of privacy rights. Okay. I think that was there anything else you wanted to say, John? I sort of went off on a diatribe there.
No, not specifically. I think I actually think what we spoke about there was quite valuable. There were one or two other little bits and pieces in the chapter which it is worth bringing up. Obviously, there was the response of the Data Protection Commissioner, which, as expected, I mean, they kind of came back and she said that they couldn't identify any issues arising under Data Protection Acts, which was what we spoke about earlier. It was blatant diversion and not standing up to... it's a conflict of interest, essentially, and when they're caught out, they just don't want to deal with it. So I think the breach in privacy rights by Irish Life and Permanent is worth having a quick look at as well.
Okay, just to remind myself, this letter was written to... It was written to Katrina
Katrina Holland was the Data Protection Commissioner. We've Stuart Fennell and Katrina CC'd on this one.
So this is where we inferred to them like that. Basically, we gave them reasons why they should be involved on non-notice. Now, at this stage, this was not a complaint. So you could put in a complaint, but this was not a complaint. It was just putting them on notice that they need to sit up and watch what was going on. Mm. So Tom told them that basically he looked forward to their support in the matter and gave them reasons why they should consider staying in the game. So he specifically inferred here or said, have sole traded. So I'll read out the actual line. Information has been brought to our attention. Now he's writing again to the Data Protection Commissioner. Information has been brought to our attention that Irish Life Permanent TSB has sold, traded, swapped or exchanged personal data in relation to the acts, and we have reason to suspect that they will try to withhold data and information as per the data request, as the data request of 23rd of April. So we were telling them the reasons why we wanted them involved in it, which was good enough. I mean, I don't think they wrote back and said they weren't going to continue to get involved in it. So as things transpired, which we'll cover later on as well, is that Tom never actually got the data and information that he requested from the bank.
Yeah.
So that itself, was a breach alone. And coupled with that, we suspect, we can't say we know, but we suspect that the reason he didn't get the data and information is because when they send you the data and information, they have to send you all of the data and information. So looking at the game again, or the strategy, the data request was sent in. So Tom then had 40 days before legally the bank could do anything.
Okay.
The bank couldn't take any further steps until all that data was in Tom's possession. And even if they did, and it went to the point where it was in court, the judge would say, well, actually, they don't have the information, so we can't proceed. So the judge himself or herself would have given an extension of time, or what do they call it when you look for a delay in proceedings, a stay or else an adjournment. So they knew that there was no point in them going legal until such time as all the data was out. So in the interim, Tom wrote them a couple of letters, which are in the book, of course, and he was writing to all the different parties. So they now knew that Tom knew there was more information that they would normally give to the average man. They knew that he knew there was more information required. Mm. And they didn't want to give him it. Okay? If they gave him one part, they'd have to give him it all, which meant that they'd have to go back and start checking what happened to this alleged contract.
Yeah.
Was it securitized? Was it exchanged, swapped, traded, so on and so forth? So if they didn't give them that information, they were then in breach of the Data Protection Act once again. But it was more serious this time. Now, let's just say, hypothetically speaking, if they had to return the data, okay, then Tom probably would have logged the data and then sent them back a letter to say, well, look, this is what I have received, and spelled out to them what they'd sent him, which meant that they knew what they'd sent him, he knew what they'd sent him, and then he knew exactly what had been sent, and it was logged. So therefore, no further or new evidence could ever be brought in again in a court of law. Mm. Okay? They cannot introduce further evidence. That is the evidence on which they're basing their allegations. So they cannot then bring any further information in, because then it's a crime again. Because what they're doing is they've withheld evidence. Yeah?
And that's very important.
Oh, it is very important. It's very important that if you do get a data request fulfilled, you log it in detail and send them back a confirmation to say, this is what I got, or this is what you got.
Yeah.
And that precludes them then in law from bringing any further evidence into play. And if then they do try, they'd be guilty of then withholding evidence. So then that's an obstruction of justice, which is criminal again. So they're stepping across the line all the time.
They're damned if they do and they're damned if they don't, which is exactly where we need to get them.
Oh, absolutely. So this is one of the reasons we suspect that they were never intending after a certain point of going to court. And they didn't, obviously, in this case. They may in the future, we don't know, they may come up with something else in the future. We're not precluding that chance. But we suspect that because of the questions that were asked, they did not want to disclose all the information that Tom legally was entitled to. Mm. So therefore, they couldn't go and face the court and say to a judge, "Oh, sorry, Your Honour, we don't think that's relevant." Because Tom would be smarter than that and say, "Well, of course it's relevant because of A, B, C, and D."
Yeah.
Okay? So, again, they can't be seen to withhold information. So they're damned if they do, damned if they don't. In this case, I don't think they were left with any other options but not to go to court, to be honest with you. I don't think they could afford to go to court because Tom was prepared to stand in that court and fight them point by point on legal point, of course, legal and lawful points. So he was prepared to do that. And they were getting an idea of that at that stage as well. So I think that sort of covers the chapter, does it, John?
I think it does. I think we've gone into some very important detail on that, which will set us up nicely for the chapters to come. And chapter 6 will be the follow-up, which we'll attack next week. So thanks again very much, Des, for your time and your expertise on this one. I think this story is starting to pan out in a very, very interesting way. And I mean, the feedback we've been getting from it has been excellent. So people are certainly finding value in it. So thank you very much for that.
Well, I'd just like to say, John, thanks once again for carrying out these set of interviews. And I'd like to encourage the listeners to share the YouTube recordings as well. Just let people know that they're there. Start from the first one and work your way through the whole things, because it actually will teach you. You know, it took us practically 12, maybe 14 months to put all this together. So there is a good body of work in it, and there's so many angles that we've covered and we've thought about that it really, look, when we started off like this, we kind of suspected that this was a fight we were going to win because we set out our stall to win. There was never any intention here to let go of anything, and rightly so with Tom as well.
Yeah.
So I think you'll get an awful lot of very, very valuable nuggets. And if you just follow the chain of events as well, because in there somewhere you may be someday, and there's no reason why you can't reverse things at any stage.
Exactly. And that's very important for people to note. All is not lost. So
correct.
It's important that people don't go down the road of despair, because it's completely unnecessary. And in essence, that's them winning, and there's no need for them to win.
Oh, yeah, that's right. There isn't a need. You're absolutely correct, John. That's a good note to end it on.
Fantastic. Well, looking forward to speaking to you again next week, Des. Thanks a million for today.
Thanks very much, John. Take it easy.